Well, Your Honor, I have to ask you, what happens when this case gets to the Court of Appeals, the Sixth Circuit Court of Appeals, and they see that you refuse to apply the law that it had set down that you should know about? Well, we're here with KingCast Mortgage Movies, and I got a call again from Patty Busby in Ohio. Now, some time ago, I had written about Slorp versus Bank of America and how it was extremely damaging to the bank in her foreclosure battle. Well, I lost track of things for a while, but lo and behold, she's back. And she's the one with the FTCPA and RICO claims against Bank of America. She had the exact same claims as the plaintiff in Slorp versus Bank of America at the district court level, involving a dirty chain of title and fraudulent assignments. Now, at the time, she was dealing with the district court decision, which was pretty good for her. Okay? Well, in her case, Magistrate Merz, yes, actually his name, but with a Z instead of an S, ignored all of that, as well as a decision in a case that he had authored himself some time ago, relative to what happens in a federal court after the state court becomes complicit in corruption and you never got a fair shot. Anyway, he ignored all of that. And, I know about this sort of thing because involving federal magistrates, because I had to make Magistrate Judge Langia B. McCafferty in New Hampshire recuse herself after she failed to disclose that she worked for the same law firm as a defendant in a free press case, Senator Kelly Ayotte. And not only that, she worked under my opposing counsel, who was and is a named partner at that firm. It's incredible. So anyway, not only did Merz fail to address his own prior case that he authored, he refused to take judicial notice of the new Sixth Circuit law involving Slorp, which just came out last fall. And the Slorp case on appeal said that because of the bank assignments and the busted title, it doesn't matter one bit whether the homeowner was allegedly in default. And that's what Miss Busby was arguing all along. She might owe somebody, but she doesn't owe Bank of America. But Merz didn't want to hear that. So the same day she filed for judicial notice of the appellate case, he threw it right back out, ostensibly because she was tardy in mentioning it, because that case was decided last fall. But that's bullshit, and I'll get to that in a minute. She went back at him yesterday with a motion to reconsider, citing the rule that says the court may take notice at any time and must take judicial notice in situations like this. So let's see what he comes up with next to throw her case out. It was his duty, in the first place, to peruse the current law of seminal cases cited by either party before issuing his decision. That's what, judges are supposed to do, right? But for some reason, he didn't do that before he issued his report and recommendations to dismiss Busby's complaint against Bank of America. You get it? Because the Slorp decision was already out when he issued his report and recommendations a few weeks ago. Why didn't he cite to it? Anyway, the law firm involved in this case has a history, a documented history of fraud in mortgages and discrimination in the workplace to boot. But none of that matters at all to Magistrate Merz. No, sir. Just, for shame, Your Honor, for shame.